Good afternoon, everyone. Thank you for attending our webinar today discussing the California Voting Rights Act. A few things to get us started. All of your telephone lines are muted, so any questions you have during the seminar must be submitted using the Q&A button on the top of your screen. Jason and Nari will do their best to answer all questions during or at the conclusion of the webinar. If your question isn't answered, we will follow up with you after the webinar via email. We are offering CLE credit for this webinar. Certificates and a copy of the PowerPoint will be emailed to all attendees next week. Today, Jason and Nari will discuss the legal challenges, financial risk, and compliance procedures for at-large versus district-based elections. Their presentation will cover the pros and cons of at-large versus district-based elections, legal and financial implications of city challenges to CVRA litigation, safe harbor provisions of AB 2123 and AB 350, and relevant compliance criteria for drawing population maps for district-based elections. Jason Rosenberg has more than 10 years of experience assisting all sizes of municipalities in a wide range of special districts. He currently serves as city attorney for the city of South San Francisco and general counsel for the Grattan Community Services District. Jason advises on matters relating to public contracting, constitutional law, land use, telecommunications, code enforcement, government ethics, public records, and the Ralph Brown Act. Nari serves as the assistant city attorney for the city of South San Francisco, city of Walnut Creek, and town of Los Altos Hills. She recently assisted local jurisdictions in the counties of San Mateo, Sonoma, and Sacramento to transition to district elections and prepare for and respond to CVRA demand letters. She has also prepared ballot inventures on cannabis business license taxes and transient occupancy taxes, as well as drafted ordinances on inclusionary housing, commercial cannabis operations, and wireless telecommunications facilities. Jason and Nari, thanks for joining us today.
Thanks a lot, Stephanie. So thanks for joining us today, and Nari and I are going to hope to just shed a little light on this new developing area of law and our experiences advising clients on California Voting Rights Act and district-based elections. Just a quick overview. What we're going to hope to cover today is an overview of the CVRA, some prior CVRA challenges that have been brought in California, some what is now considered safe harbor provisions that cities and public agencies have availed themselves to, and then the process of shifting to district elections, and finally some alternative approaches to consider and some last practice tips. So with that, I'm happy to turn it over to Nari.
Good afternoon. So I'm going to provide just an overview of the black letter law and what the California Voting Rights Act is. This was signed into legislation in 2001, took effect in 2002, but recently we've seen this be used as a tool to force or challenge cities to transition from at-large to district elections. What this does is it's a state law that expands on the rights available under the federal version. The Federal Voting Rights Act was enacted in 1965. And while the Federal Voting Rights Act had 3 different requirements, the California Voting Rights Act only has one requirement, which is that you essentially need to prove the existence of racially polarized voting. So this is a substantially lower burden for a plaintiff to meet. And a racially polarized voting is defined as where a protected class, let's say that of minority or a language, certain languages, ethnicities, the candidate preferred by a protected class is different from the candidate preferred by the rest of the electorate. If that happens, that's considered a racially polarized voting. Some of the other factors that are included in the statute as persuasive are whether or not there was a history of discrimination in that political subdivision in that jurisdiction, the use of electoral devices or other voting practices or procedures that may enhance the dilutive effect of at-large elections. So, for example, in one instance, there was examples of police pulling over racial profiling in police law. So that was, a previous practice that didn't help the city at all. Denial of access to the processes that determine which group can receive financial or other support in a given election. as well as the extent to which members of that protected class bear effects of past discrimination in areas such as education, employment, and health that hinder their ability to participate effectively in the political process. So this one is a really big catch-all, just trying to capture the concept of systemic discrimination that often exists in society. And the fifth one is the use of overt or subtle racial appeals in political campaigns. All of these are other factors that are probative in finding whether or not racially polarized voting exists. Now, as background, most jurisdictions, most cities and towns in California have an at-large election where essentially the voters of the entire town or city or special district will choose all of the members or of the governing body. What is now being requested is that these demand letters are being sent. There was a first wave in Orange County and throughout Southern California. Now we're seeing that wave come up north here in the Bay Area, and more recently even up as far as Sacramento and Sonoma County. The demand is requesting that cities or different jurisdictions transition to by-district elections. And a by-district election essentially means you take the jurisdiction, a town, for example, and to divide it into separate districts. So if there were 5 council members, you would have 5 different districts, where each district would be represented by one candidate representing that district, and that candidate would have to live in the district that they represent. And then on top of it, only the voters living in that same district can actually vote for that candidate in that election cycle, so every 4 years. There are instances, but very limited instances, of prior published challenges. The first is Modesto, where the court did find that the California Voting Rights Act applied to the city. And the second is City of Palmdale, where the court prohibited the city from certifying the results of an at-large election. So both of those cases did not favor the city. Other cities that have challenged the CVRA demand letter is Huntington Beach. So in May of 2017, the city responded with a very articulate letter. Since then, no lawsuit has been filed by Shankman and Hughes, which was one of the heavy hitters in this area, sending the demand letters out. Another city is Santa Clara here in the Bay Area. The city did lose their lawsuit against Shankman and Hughes. The court did order Santa Clara to transition to district elections, even though the voters had previously rejected that option in a June 2018 special election. The most recent is the city of Santa Monica, which more recently lost the lawsuit against Shankman in November of 2018, and it's uncertain whether the city will file an appeal. One of the reasons many of these cities are transitioning to district elections is because of the legal and financial implications of the CVRA lawsuit. Not only does the plaintiff have a really low bar to prevail, even if the city does prevail, another plaintiff could successfully allege a CVRA violation later. So the only way to be protected or insulated from a future CVRA challenge is to transition to district elections. The costs to litigate are also quite high. They can start at around $500,000, but at the same time, if the city loses, they would have to be required to pay plaintiff's legal fees. And this has ranged anywhere from $385,000 to upwards to $4.5 million. And at that point, the town or the city would lose the discretion to draw their own maps, and instead the court would have the discretion to impose district elections and draw a map based on what both parties would submit to the court for consideration. So once again, cities in Northern California are seeing a lot of these letters right now. There's an estimate of anywhere from 40 to 60 different cities or perhaps have some kind of letter. More recently, in the November 2018 district elections, the following cities have already transitioned: Santa Clara, Santa Rosa, Menlo Park, Concord, Martinez. And then for November 2020, district elections are happening in South San Francisco, Half Moon Bay, Redwood City, and a lot more are currently in transition. There were 2 safe harbor provisions that Jason mentioned. First was enacted in 2016. So this would allow the city or the town to cap their liability at $30,000 instead of an uncertain number. So but there's a very prescribed protocol that has to be taken in order to take advantage of this. First, the city or the town has to adopt a resolution of intention to transition within 45 days of receipt of the letter. So once the letter is received, that starts the clock. And then after that 45 days, there's a subsequent 90 days that the city would have to hold 2 public hearings for public input, even before any maps are drawn. Once those 2 public hearings are held, then another 2 public hearings are held to draw the actual map. And then there needs to be an introduction and adoption of the ordinance. More recently, in 2018, the governor signed another safe harbor provision, AB 2123, which took effect beginning of this year, whereby if the city entered into a written agreement with the prospective plaintiff, they could then extend that initial 90 days to another 90 days for a total of 180 days to do those 4 public hearings and introduction and adoption of the ordinance. Now, I think one of the big questions is, what is districting? I mentioned that essentially this is where you're taking a jurisdiction and you're dividing it into different districts, and those individual council members have to reside in that district, and they're voted by the folks living in that district. The process of doing districting requires actually drawing boundaries that would divide the city's population into districts. And Jason will go into more into what that actually means. One of the things to keep in mind, though, is that with every U.S. census every 10 years, those district boundaries might need to be redrawn if there's a large change in population. For example, if there's a large residential development happening in certain parts of the district, you would anticipate that you would need to redraw the maps after a U.S. census. So now I'm going to hand it over to Jason, who's going to walk through what is included in the mapping criteria.
Thanks, Nari. So when an entity chooses to move to district elections, there is a specific process, and now with this extended safe harbor, it can go over a longer period of time. But even in 180 days, that's the longest under the safe harbor if you enter into an agreement, it still happens really quickly. So you really kind of need to be ready to move quickly, have the meetings, and get the public input in order to be able to adopt within the time frame. And to do that, you're going to be looking at certain criteria for how to draw these districts. And oftentimes, we always recommend utilizing a demographer in addition to legal counsel for this process, because a demographer is really going to help with some of these actual drawing the maps and the boundaries is what they specialize in, and it's very helpful to have someone who can do this in a way that will be defensible, because there's, as I'm going to go over, there's requirements that you need to comply with for the maps to be, district maps to be lawful. So when you are drawing maps, you need to look at these 5 criteria. It has to have rough equal population. There could be a slight variation, but for the most part, needs to be equal. It needs to comply with the Federal Voting Rights Act. The boundaries need to have contiguity, compactness, and then respecting communities of interest. And I'll go into a little more of those in more detail. So the equal population is essentially one person should amount to 1 vote. However, there is a deviation allowed, and it's about 5% between the districts. So you can't have 4 districts of, say, 10,000 population and then a 5th district of 20,000. It could be 105 or 90, 15,000 or 95,000 within the 5% range, but you can't have something that deviates greatly. So they need to be balanced. Obviously, you can't have intentional discrimination or racial discrimination, and that's goes without saying, but helps to have that as some of the criteria when you are drawing these population maps. Ideally, the total population would is how you draw it up and divide it up equally. The other things to consider is, depending on how you draw up the districts, you can do it with, let's just say you have 5 council members, then you could have 5 districts with each council member represents each district. Or if you had 4 districts with an at-large elected mayor, that it would be 4 or divided by 4. So each population would be about 25,000, as opposed to if it's 5, you're shooting for 20,000 people per district. So, second criteria, you want to respect and comply with the Federal Voting Rights Act. You have to make sure that the protected class is not just race, but it's also a language minority as well. So that would include Asian, Native American, Alaska Native, or Spanish heritage, and that's based on federal law. You can't have the purpose or effect of discriminating on the basis of race, and it applies to all jurisdictions that conduct elections. And this is really where you get to the key issue, is the idea of vote dilution, and you need to try to avoid that. And it doesn't necessarily mean that one protected class has to be able to vote for that protected class. It's just that protected class of voters' ability to elect the candidate of choice. So it's possible that one protected class in voting patterns could show that they will elect candidates of a different protected class or of a different group. And if that is shown, then, that is relevant for drawing up districts to make sure it preserves and it adheres to the Federal Voting Rights Act. There's also some other methods of vote dilution, which is cracking, where you divide a minority population so it does not constitute a majority in any district, or packing, where you put one minority population into one district, even though it could be in multiple districts. So and again, this is all getting to the issue of diluting a protected class's vote. And when you're doing these maps and you're drawing them, you still can't have race be the predominant criteria. It can be a factor, but it can't be the driving factor. Compactness is really, you want it to be the district to stay close together. This picture on here, this is Maryland's 3rd district. This is kind of the example of a gerrymandered district that is the opposite of compactness. And this is considered the praying mantis of district, the way it's spread out and carved out specifically to have certain areas and not other areas. And this is what the Federal Voting Rights Act is trying to avoid. And then contiguity is related to compactness, but it basically says that all the parts of the district are connected, and you can go from one location to another location in the district without crossing district boundaries. So the way that this district map on this page has some little islands is what you're trying to avoid as well. And then the 5th criteria, this is the first 4 generally are shown through data and are pretty objective. Criteria 5 can get more into the subjective, about looking at external factors to essentially protect communities of interest. And this is oftentimes during the redistricting process, where you really are soliciting input from resident stakeholders to get an idea of what populations share common interests, whether it's social, economic, religious, whether they go to, transportation, certain parks or schools, or, some neighborhoods have a neighborhood association that you want to try to protect, or there's a park that is kind of the unifying feature of that neighborhood, so you want to have everything around that park be part of that district. It's basically you get a lot of little communities of interest, as these are essentially the building blocks for the districts, and it helps to have shared interests be part of one district is really the goal with that. So when you actually draw, this is a sample of a map that was drawn. This is for Santa Rosa. This is what it looks like when you go from at-large to district elections. This is for a 7-council member city, and you can see that they really are trying to preserve the neighborhoods. It's compact. It kind of geographically makes sense. For some cities, where if you do shift to district elections, where the lines fall are almost people could almost guess they're logical based on the geographic features of the city. And some cities or districts are easier to draw onto maps than others. We had a client whose neighborhood just kind of naturally fell into 5 districts. So when the shift happened, it didn't have a lot of versions of maps that kind of coalesced around some common themes. And you'll sometimes see that when you start to draw maps, if you present them to the community for their input. And something else that is worth discussing is so when you do start this process of redistricting, you have to move quickly, and that sometimes does not allow some more input than communities would want. And ultimately, it's the governing body. So if it's a city council, if it's a city, it's a city council that will be ultimately choosing the map and adopting an ordinance to adopt the map. But there's times where communities want to get input from whether it's an independent committee that gets delegated and authorized to adopt the maps after public hearings, or if it's an advisory committee where they're really just reporting and making recommendations to the ultimate deciding body. Both of these are authorized in the elections code and are permissible if you do receive a demand letter, but it just creates a practical problem because of the time and the speed in which you need to adopt new maps, that sometimes to form a committee and to give that committee some meaningful responsibility and input, you need more time. So in some of the recent shifts based on CVRA demand letters, our office is not aware of a lot of independent committees that were formed to ultimately decide, but it's an option. But maybe with the new law coming into effect that'll expand the safe harbor period, that may allow for more of the use of some of these committees. Another option that some can consider is when you do shift to districts, you still keep an at-large and elected mayor. So the mayor will represent the entire city, and then you have 4, if it's a 5 council member, you can have 4 districts with 1 at-large mayor, and that is authorized by the government code. If you're ever considering that, we found that it's easier to do that shift at the same time that you're shifting to district elections. There is a process that you don't have to do at the same time, but it's pretty cumbersome. And if you're already going through the process of drawing district maps, you are considering an at-large mayor, you probably would want to put that into the process. And part of the thing to think about that is then there'd be 2. Whenever there's a district election, you could just structure it so that there's always someone being elected for the entire city, the at-large mayor, whether if it's a 2-year term. If it's a 4-year term, then as this slide shows, you'd have 2 districts plus an at-large mayor in 2020 and then the other 2 districts in 2022. You can structure the at-large mayor to be different term lengths than the council district seats. So now this is kind of getting to the part of the process that a lot of cities that have shifted to district or public agencies that have shifted to district elections have kind of gone through this same process, in that you really do deal with kind of these 5 stages of grief when you are shifting, because the council can be very diverse in many ways, whether it's religion, ethnicity, identity, whatnot, but it doesn't really matter if there is a demand letter that shows there could potentially be racially polarized voting for one group. It doesn't matter if you have a council that is full of diverse members, but not representing the group that the demand letter is based on. You still are subject to liability if you do not shift. So I went through this with clients, Nari has as well, and it's this process of you first really They can't believe it. They're trying to find a way to fight it, and there's anger and frustration. And then ultimately it moves to, bargaining and then acceptance with, okay, this is kind of where it's heading, and then they kind of get on board and get behind the process. Because these are demand letters, there's a risk of litigation. You can discuss that risk of litigation in closed session. And there's also this question of, incumbency. The elections code says you can't cut short any current term. So the seated electeds are safe, so to speak, in that their terms aren't going to get cut short, but you are going to shift the way that they get elected in the future. So how you handle that with moving forward about drawing maps is just a topic that oftentimes comes up, and agencies have dealt with this differently. Another thing to think about when you are faced with a demand letter is the idea of practical implications of working with county elections office regarding when they need certified maps in order to get on the upcoming election. So in our experience, the demand letters that have been received to date really are urging, shifting to district elections as soon as possible in the idea of ending what they're viewing as racially polarized voting as soon as possible. But you just have to balance that with the practical considerations of, if the county elections office can't certify them or get the election shifted to district elections soon enough, then it's really not possible. You need to kind of balance those considerations. So it's something that you kind of have to be aware of immediately. As soon as you get a demand letter, you need to kind of start jumping into action with working with your counsel, but also talking to the county, whoever's handling the elections, to make sure that you are aware of external deadlines as well. Expand outreach, you really want to consider, translation of the material in as many languages as are used in your jurisdiction. We've seen some cities make interpreters available at all public meetings and do a lot of robust outreach. So going to the faith groups in the jurisdiction, farmers market, high schools. We saw one that was pretty interesting, is that a high school had the submission and the drawing of maps following those 5 criterion as a assignment for their students. So we had over 40 maps submitted for one city that was just from a high school class, civics class, which was interesting, and it got them engaged, and it was really interesting to see how those maps were similar and different from some of the public maps that were submitted. So that is kind of the run through quickly. We have a number of questions which we will try to get to.
So a question that keeps coming up is whether or not there are exceptions for small jurisdictions where either in terms of square footage, square mileage, or in terms of the population size, and the answer is no. There have been previous attempts to have the legislature impose some kind of population exemption, or maybe anything less than 30,000, for example, and those have not succeeded in the past. So as the law is currently drafted, it does not have any exemptions for whether or not you are really relatively small jurisdictions, or whether or not you even have a currently quote-unquote diverse council. As Jason mentioned, it's the way the racially polarized voting is defined is quite broad in terms of, as long as you show, if there's a prior election where you can show that the candidates preferred by one protected class was different from the candidates preferred by the other class, that is something that is weighs very heavily in favor of the plaintiff.
I also got a question about just the timing a little bit. So I wanted to, let me go back and find that slide on timing. So this is a lot of what drives the quick structure that Nari mentioned, and I just wanted to highlight this, is the minute you receive a demand letter, you have 45 days by which to adopt the resolution of intention to transition to by district elections. Once that you make that decision, let's say to shift, you adopt the resolution of intention, then from that point, the 90-day clock starts on holding 2 public hearings for input, holding 2 hearings to draw maps, and introducing and adopting an ordinance. So at the longest, if you do want to avail yourself to the safe harbor liability cap of $30,000, it's going to, from the day you get the demand letter to the day you adopt, it's going to be a maximum of 135 days. It could be shorter if you adopt your resolution of intention sooner than the 45th day. Oftentimes cities do that. They adopt it sooner just because of the schedule of their regular meetings, and they want to do it at regular meetings for maximum participation. But this liability cap, and this is really one of the reasons why a lot of the agencies do shift. We got some questions about why are there more agencies fighting this? And part of the thing is that it's a very low hurdle to clear. And if you lose, you not only don't get to control the process, the maps and the timing gets imposed on you by a court, you pay your legal fees, plus you pay the successful plaintiff's legal fees. We're not aware of any city that has won yet. And even if a city were to win, they just live another day. They could get another claim on a different group that has a claim of racially polarized voting, and you have to fight this fight again. So a lot of these factors, in some ways, these cards are really stacked against the public agency. And that really gets to some of the, counseling the council on their options. Of course, they could fight, but you really are stacked against you. So this safe harbor, it starts a really quick clock that you got to move quickly on. And there were some questions about that, so I just wanted to highlight that because that really does drive the actions.
Yeah, and just to follow up on what Jason was saying is that we did receive an update that I believe from the city attorney for Culver, Carol Schwab, has updated us that Santa Monica did file an appeal and that they are requesting a stay of the trial court decision. So we don't have any definitive final holdings that are favorable for a city or jurisdiction yet, but we did just want to share that update that Santa Monica has filed that appeal. One of the other questions related to the safe harbor is is this required? The safe harbor isn't required per se, but if you're not going to avail yourself of the safe harbor, you're essentially preparing to defend yourself in litigation. And so at that point, there is no need to do the public hearings because those are only required if you're trying to avoid litigation. So the options are, you could do the kind of like a ostrich, hide your head in the sand and pretend you never got it. Some cities in Southern California, I have heard anecdotally, did that and they never received the letter, but perhaps at that time Shankman or the other plaintiff attorneys were very busy with the Santa Monica litigation or other litigation. Another option is to fight it, so that's the litigation path and possible fees associated with it. And the third is to prevail yourself in the safe harbor and conduct those public hearings and transition. And then another question that came up was whether or not the candidate has to live within the district. I just wanted to clarify that the way that the California Voting Rights Act provisions are written is they talk about a transition to district-based elections. In reality, there are actually 2 types of district elections, from district and by district, which are recognized by the elections code. And this is kind of nuanced. The from district requires that the candidate live in that certain district, but all of the residents of the city would be able to vote. Whereas by district is where both the candidates have to live in that district and the residents voting for that candidate have to also live in that resident. So when the California Voting Rights Act talks about district-based elections, they're actually referring to the more nuanced by district elections. Are there any other?
And there's also a question about for the letter for the Huntington Beach, and after when the certificate is sent out, we're happy to share that letter. Huntington Beach took exception to the demand letter and said, no, we're not going to shift. They're really the only one that we've seen that have really challenged and not received suit. We think a lot of the challenges to demand letters have resulted in lawsuits. And another question to that is kind of signs or criteria that would make a city likely to get a letter. It is our understanding that at least I know for Shankman and Hughes, who does a lot of these lawsuits, they have a demographer that either is on contract or that is like on retainer that will do data analysis of past elections to find something in there that they believe is meaningful. They're not just kind of blindly throwing demand letters like on a dartboard. They actually have some basis for when they file it. We had an experience where there was one client that we received a demand letter. The claim was based on an election in 2013. It was an off-year election before shifted to the statewide election cycle, so that's lower voter numbers already. But it showed a data analysis that showed one minority candidate getting significantly better results in precincts that were that same class as that minority candidate. But it didn't look at all these other factors in that particular election as to who that candidate was, who that candidate was running against. A lot of factors in there that, the city would have used in its defense, but there was enough there for them to send a demand letter that there was enough there that the fight would have been some ways a coin flip, and then, you just live another day, as I said before. So unfortunately, the bar is low on some of these claims, and that is probably why you have not seen a lot of lawsuits defending at-large elections. But we do know that some of the plaintiffs' firms that bring this have, not necessarily a demographer, but someone that is looking at voting records in the past, precinct voting rolls and records, and come up with something. We also heard that some organizations are now getting involved, so it's not just Shankman and Hughes that are bringing lawsuits. We heard that MALDEF has brought a suit. So it's not just plaintiff lawsuits. So, this is an evolving area. We also understand that there may be future legislation, but, it's hard to tell right now because of some of the stuff is in flux about how the state is going to react to some of these lawsuits.
Yeah. Another question that came up was whether or not these laws apply to charter cities. And the Elections Code clearly defines political subdivision, which is subject to the California Voting Rights Act, as including both general law and charter cities and counties, as well as school districts, community college districts, and any other district that's organized under state law. So it's very comprehensive. And that has been litigated and did not go in favor of the charter city. So it does apply to charter cities. Another question that came up was whether or not a city could wait until the 2020 census, because you're just going to have to redraw it anyways. And that's a very valid, practical argument. That argument generally that's something that would have to be negotiated with the attorney that sent the demand letter. We haven't seen them be interested in entertaining that, just because they want the transition district elections to happen as soon as possible, because the concept is that the voters are being disenfranchised right now and that they should deserve a remedy right now. And so in those instances, it usually would have to redraw it after the census. In terms of practical implications, it's a lot easier to redraw with some of those population deviations than it is to draw it the first time around. So that's something to keep in mind. Another question is whether or not, our situation that we've been talking about is actually assuming a city or jurisdiction does nothing and then they receive this demand letter. And the next question is like, what do you do? But there are actually some clients that are thinking about proactively, voluntarily transitioning to district elections even before demand letters are received, because they know in the past there was, an Asian candidate that was preferred by Asian voters in their city, but that person lost. And so they know that prior election has this pattern of racially polarized voting, so they decide upon themselves to proactively transition. In that situation, there is no need to follow the safe harbor provisions, because those safe harbor provisions only get triggered if a demand letter is actually received by the city or town. Another question that came up was this tension perhaps between the California Voting Rights Act and its federal counterpart. And that question has also been addressed in previous litigation. The California Voting Rights has been upheld as being valid, and so we don't expect that to change. Essentially, the Federal Voting Rights Act is creating a minimum, and what the California Voting Rights Act did is expand upon that, but it doesn't exceed it. It just makes it a lot easier, but it doesn't create different requirements. It just makes the requirements easier. So we don't expect that to happen.
We're just looking through, trying to find some questions we haven't answered. If some we aren't answering at the meeting, they're more individualized, and we can answer those offline after the webinar. Take one more, and then we'll wrap it up.
Question came up about the likelihood of Mission Viejo being successful in their settlement. And so my understanding is that in July of 2018, a court ordered that Mission Viejo could go to cumulative voting and is not required to go to district elections. And so right now, after speaking with the city attorney for Mission Viejo, they are currently figuring out practically is that something that can be done, because it requires special voting, special voting machines. Cumulative voting, as background, is essentially if you have 5 council members, every resident would get 5 votes, and they could take those 5 votes and give them all to their favorite candidate, or they could disperse them however they want. And so that has already, so we're excited with the city. This is the first city in California to try this. They are waiting for an opinion from both the county registrar's office as well as Secretary of State on whether or not both of those entities could confirm and validate the cumulative voting process, because it hasn't been done in the state yet. And then alternatively, the court order also included if cumulative voting doesn't work, then at that point the city would need to consider moving into the district elections. And so that's our current understanding of Mission Viejo. And then there was one last question I see about in hiring interpreters or translators. You do that according to the highest minority population. In one client, they actually did 3 different languages, Tagalog, Spanish, and Mandarin Chinese, I believe, based on that was just the ethnic makeup of their city. But it's not a legal requirement. That's just something that's done more on the basis of the city's preference.
Okay, well, thank you everybody for joining us today. We have a couple questions that we will follow up via email individually. And like I said earlier, a copy of the PowerPoint and CLE certificates will be distributed early next week, along with a copy of the letter that we'll get from Jason and Ari. Thanks everyone for joining us. Have a great day.